Thank you, Honorable Speaker, for giving me the floor. Honorable Speaker, let me join my colleague to thank the CRC and the Attorney General for presenting this important document to this August House. Honorable Speaker, other speakers have said it is history. We are promulgating a constitution on top of an existing constitution. I think this is the first time it happened in the Gambia. The 1997 is guiding us on the transition of the 2020 draft. Honorable Speaker, my first submission to the Attorney General is on the supremacy of the Constitution. Because, Honorable Speaker, this clause, many members have actually forwarded it to the Attorney General. But for me, when I saw that clause, the legality or the validity and the legality of this Constitution cannot be challenged to court. I have to make a little research because at that time I was not comfortable actually with the clause. And then I knew that this submission might come from the judiciary. Then I make effort until I get the observation of the judiciary on this clause. And then, Honorable Speaker, since we are coming to decide on this important document, and then tomorrow, whatever happens to every citizen or to any of us, we're going to resort to the judiciary for its interpretation. And then if you can allow me, let me read that piece of observation with regard to this clause. Honorable Speaker, is read, challenging validity of this Constitution, clause 7.3 of the draft Constitution provide as follows. The validity or the legality of this Constitution is not subjected to challenge by or before any court or organs of the state. This provision, in our view, insofar as it seeks to oust the jurisdiction of the court, is inconsistent with the principle of access to justice and to the court. It is irreconcilable with the principle of the respect for the rule which permeates the rest of the draft Constitution. However, no. How else should citizens be able to challenge the Constitution other than in the court of law? Why should the right be taken away? No cogent reason can, in our view, support such a proposal. We recommend that this provision should be deleted from the Constitution. Honorable Speaker, this is, I'm not saying it is actually what happened, because these are legally texted, and when I saw the provision, I have to make my research since I get until I get the submission of the judiciary. So, Honorable Speaker, Honorable Minister for the Attorney General, I would definitely want you to help this House to understand this clause, because this is dealing with the supremacy of the Constitution. And if the custodian of this Constitution have got a reservation at the drafting stage, definitely something should be done about it. Honorable Speaker, my next point is on the discrimination aspect of the new draft. We have seen a lot of discriminatory clauses in it. People have been talking the issue of the judiciary since yesterday. They were talking about their emolument and their retirement benefit. But I believe there is some discriminatory aspect also there. Because if you looked at the judges, a judge is just a judge. You have some judge that should be appointed by the president and confirmed by the assembly. You have some judges that their appointment should be under the Judicial Service Commission. So I don't know why are they treating their appointment the same differently, and that is they are treated them differently. The other aspect of discrimination also is about the retirement benefit. It is treated differently with the entire civil service of this country. Because the way pension is computed in our civil service is your total emolument, your length of service, then it is computed in that way. So that means that the retirement benefit of the judges and the other aspect of society is treated differently. That also is another issue. And actually, both the new constitution and the 1997 constitution, none of this is accepting discrimination. We go to the 2020 draft. We see what it means by discriminatory. It's somewhere else. Sure, I just want to see what the law said about discriminatory. I have it. Protection. I'm looking for, I have it here. I mark it somewhere else. Just a minute. Okay. That's section 69. Talks about protection from discriminatory. And this is a fundamental right. And it is all persons are equal before the law. No law shall make any provision which is discriminatory either of itself or in its effect. So we have seen the discriminatory aspect in this in the new draft itself. And then almost is the same text in the 1997 Constitution. Then, therefore, Honorable Speaker, promulgating any law that is discriminatory is against both this one and this one. So I don't know how would the Assembly proceed with legislating laws that are actually discriminatory. Honorable Speaker, the other discriminatory aspect of it is on that is affecting the sitting president. The matter is not about the president. We are legislating, and as long as we are legislating, we should legislate laws that suit everybody. If you look at, the matter is not about the term limit. I'm talking about the discriminatory aspect of it. According to this constitution, his current term is not counted. And then actually he was given that right on this constitution. Now if we go for election, if a person wins other than him, will serve 2 terms. But for him, if he wins, he serves 1 term. That this is totally discriminatory. Are we going to enact law, especially the 2020 draft bill itself? It tells you, don't enact me as a law if I am discriminatory. So what will be the approach? Honorable Speaker, done with that one. Honorable Speaker, the member for Jos 1 was mentioning a clause. I think it is clause 27. Clause 27 and clause 29. Clause 27 and clause 29 of the 2020 draft bill. Honorable Speaker, there are some laws, they are heartless. And being people representative, we should be very mindful of those laws. Clause 27, restriction on the activity of a public officer. Here it is telling you, if you are employed by the government or any public institution, you are not going for any gainful employment. Honorable Speaker, our brothers outside, if they travel outside, they work for 24 hours, 16 hours. They are given that right in foreign countries. Us, our own people, we deny them a right that they are given outside. I think we must think logically. Let us look at the laws that we are putting in place. How many Gambians in this country, their salary can sustain them even 1 week? And you are telling me if I have the energy, I have the power to work for government 8 hours and then go and work somewhere 8 hours to improve my living. You said no to that. And you want me to append my signature on that law. I will not do it. You go to section 29, and that is the worst one. Section 29, consequence for contravention. You go to sub 3. Any person who has been dismissed or otherwise removed from office or whose relationship with an organ or agency of the state or a statutory body or a state-owned enterprise have been terminated shall A, in the case of a public officer, be disqualified from holding any other public office for life. For life. What are we doing? We are enacting laws that will be killing our own people. Our own people that we say we are representing, and we want to enact such. And we say this is a draconian law. Which law is more draconian by this clause? We are here to enact draconian laws, and we are enacting draconian laws. What is more serious than this one? These two clauses alone disqualify this 2020 constitution. These two clauses alone, because it is affecting directly the people we represent. We are banning them from work for life. When the Jana Commission submit in report here, there are some people who were banned for life, and it was a public outcry. Today we are legislators. We are asked to legislate that. Today we are legislators. We are asked to legislate such laws. And we say it is progressive. One rotten potato spoiled the whole lot. And these clauses have spoiled this constitution. Honorable Speaker, I'm just on the session of the National Assembly. That is a beautiful clause that I wanted to add, because, Honorable Speaker, I was expecting, we have a very innovative standing orders, and we are drafting a law. If we look at currently, how many bills do we refer to various committees? I could have loved this CRC to look at our standing order. Then our session be at least open, because our standing order, the way we treat bills, We will have a session, refer all those bills. We will not finish the process of those bills. Then we go again, the next session, we have another bill. That means that we are working with backlog. If you don't mind, we will, our time will finish. We still have some backlog of bills to treat. Then, since we are coming up with a new standing order, with a new constitution, I think the sitting of the assembly could have been considered at least open. We have a long recess, so that we can handle all our bills in a session. But the way the trend is moving now, we might exit this term, but still we will have some bill behind. And then I believe it could have been definitely looked at least our session. Instead of quarterly, we open it. Then we have a longer recess, so that we can handle our National Assembly business according to our standing order. Because presently, our standing order did not match with this quarterly sitting. I was actually expecting that. Honorable Speaker, I had some intervention. Others are saying, let's legislate it, and then after, we come and amend. For me, I cannot understand that as a legislator. When it is wrong, it's wrong. You dare not to legislate it why it is wrong. Then you come back and say you are amending it. That's wrong. That's a wrong process. Once it is wrong, it's wrong. Let it stop there. If we don't have any way how to amend it, let it stop there. But the thinking of say, no, these are closing, some of them are positive, why not we legislate after we come and amend? That's not the case. That's not how we legislate. Honorable Speaker, my submission will be a little bit short because most of the bullets were fired. So, Honorable Speaker, the other issue is about Section 108. That is the reason for filing an impeachment for a sitting president. That one of the clauses, for me, is very straightforward for me. When it reads, one of the violations is violation of the Constitution. You see, any sitting president can violate the Constitution. But according to the way it is text in the 1997 Constitution, it's more preferable. Willfully violation. If you violate it, willfully. But just to violate the Constitution, that means that every month we will file a motion for impeachment for the sitting president. Because it's easy to do it. You can do it without willfully. But why don't we consider it and look at it, rather than leaving it in this way, we have willful. If we willfully do it, I don't have a problem. But sometimes also a human being is a human being. He can do it while it's not willful. And it can definitely land him to something. I think we need to look at that provision. Honorable Speaker, now is on the issue I did with discrimination. Honorable Attorney General, as I mentioned earlier on, we are promulgating a constitution while there is an active constitution guiding us. And then I will want you to help me here. If you go to section 100 of the 1997 Constitution, that deals with legislative powers of the National Assembly. I just want you to guide me, because we are in a process of legislation. Section 100, and it reads, the legislative power of the Gambia shall be exercised by bill passed by the National Assembly and assented by the President. So it seeks that clause 2 is bringing a limitation or a restriction. The National Assembly shall not pass any bill to establish one party's. It's not talking about law, it's talking about a bill, and we are dealing with a bill. To establish one party state, to establish any religious or any religion as a state religion, or to alter the decision or judgment of a court in any proceeding to the prejudice of any party to those proceedings, or to deprive any person retroactively of a vested or acquired right. But it continues, but subject thereto, the National Assembly may pass bills designed, I underline the word designed, to have retroactive effect. And then I want, Honorable Attorney General, for you to guide this assembly what this clause is saying. Because as I said earlier on, we are legislating, but this is the guiding principle of our legislation as long as it is still existing and active. So anything that we are dealing, we are using section 225 to promulgate this bill. But since the existing constitution, and it is limiting our powers to certain things, I think to me, it is still binding, because as long as we are speaking, it is the existing one. So I would definitely want you to help this assembly to be clarified before we even pass this one. Somebody go and challenge our decision in court, because everybody is sitting down looking at us. Honorable Speaker, let me come to our people that we assign to do this piece of legislation to us. I thank them very much at the beginning. But there is something that I will need, whether they did it or they don't, the statistic and survey, if we can get it, or if they can put it in the public domain. Because the outcry is now, is people opinion. I can understand they give us a report. That's the report I know. But they have a statistic. They have a statistic that if you look at a statistic, you can definitely know if they captured the will and aspiration of the people. Not only the report. I really need the statistic. If they can put it, if they can make sure we get it or put it in the public domain. Honorable Speaker, Attorney General, we are in the process of promulgating a new constitution. Drafting constitution is very difficult. And amending entire constitution is very difficult. Very difficult. We have the power. But you know, all this thing is technically written and they are all intertwined. So I don't know what will be our guideline, because there are so many defectives in the draft. In this draft. We are here today saying this one was amended 50 times. But if you look at the proceeding of this assembly, this one, when it comes into existence, you will not amend it 50 times. You will amend it more than 100 times. You will amend it more than 100 times. You see, this constitution, this is so explicit. It's so explicit. It looks like an act, a regulatory body. That's not how constitution works. You see, this is why everybody can just look at it, you pick up problem. Because it's so explicit. It's quite different. Even the texting, the legal texting. People are saying this is bad. Hey, constitutions are not bad. It depends on the people who are implementing the constitution. It's not that the 1997, the texting was not good, the provisions were not good. No. It was about the implementer. If you forget the rule of the constitution, what the constitution is saying you, and you rule in your own way, that is not the fault of the constitution. And this is legally text. You can be looking this one for the whole day. You hardly extract something from it because it is legally text. But this one, it is just like a grammar. You can just go in and pick problem. And this is what gives us a problem in this constitution. You know? So, Honorable Speaker, we should be very mindful on this constitution, because people are talking about 116 million. 116 million. For me, the 116 million is already gone. But what about if you subject it to a referendum, where you are going to spend another 116 million again, and you are very sure it will not pass? No. The opinion polls are there. The opinion polls are there. Nobody should talk. Before the constitution, since at the drafting stage, this 2020 constitution, it developed its problem from the drafting stage. When Christians say no to it, when Muslims say no to it, when other institutions say no to it, who are going to vote for it? Are there not those people? That's telling you that if it goes there, it's going to fail, and then you're going to waste another money again. You're going to waste another money. And that's what will happen. That's what will happen if any politician who goes inside, outside of this country, you are talking to the people. You have to look at the threshold. You have to look at the threshold that will pass this constitution at referendum stage. There's a threshold. Meeting that threshold is one of the biggest challenges. One of the biggest problem, and it will cost government a huge money to go and campaign against it. Those who are in for it, huge money to go and campaign for it. And it's going to be another wastage. It's going to be another wastage. So if we don't get what we want, let us find a way how we can get what we want to avoid the wastage. This one is donor funded. This one is donor funded. But the referendum on this one is not going to be donor funded. We are going to fund it. So the public already shown us their position. They are all keeping quiet. In fact, they will tell you, go and enact it. We are the final decision makers. So anyway, Honorable Speaker, this is what I have to say, just to show a little dissatisfaction to the CRC, the way they approach in crafting a constitution, and you are crafting a constitution depend on the reality, on what is happening at that present. And if you draft constitution like that, you lead people into a problem. The constitution was actually drafted based on the reality, just what was happening within the country. This is why it is so explicit on the concern on what is happening in the country. And this is what gives this constitution a problem. Honorable Speaker, on that note, I thank you.
Thank you very much.